Good evening. This is Rahul Reddy. Every Tuesday, live from 5 to 6 p.m., we bring in immigration updates and we take live questions. Emily, what do you have today to discuss?
Today, we want to talk about options for laid-off tech workers as the economy continues to be topsy-turvy right now and layoffs continue to be announced. Now people have more options than they've really ever had before for figuring out what to do next when you're in a layoff situation. B-2 is one of those options. How do you change status to B-2? What does the timing look like? What are your options after you file a change of status to B-2? How does that work with the H-1B grace period? So we'll go through all of that today. And then, what's going on with these companies where they're all kind of owned by the same person or same group of people, and they filed multiple registrations in the lottery last year. That's what caused USCIS to change the lottery system with all of the duplicate filings. So why hasn't USCIS acted on those individuals yet, or on those companies? What can we expect going forward on that? And then we'll talk about changing jobs after your I-140 has been approved. Do you need a new PERM? When should you do a new PERM? How long should you plan on it taking? Do you need to do it every time you change companies? We'll go through all of that. And lastly, 221Gs. This is administrative processing, is what it's commonly referred to by consulates. But is it considered a visa refusal? When you're filling out that DS-160, if you've had a previous 221G administrative processing, do you have to say that you've been refused a visa before? And if yes, how do you fill out the rest of that form and how do you proceed further? So going back to the layoffs going on, so we know we have the 60-day grace period. Job market is crazy with rounds and rounds of interviews. People aren't hiring as fast as before, and 60 days really isn't enough anymore. So how does the change of status to B-2 work? When should you file it? What's the process like for that?
Previously, when people used to file B-2 status, though, it used to take about 6 months for them to adjudicate the application. And then if they want to transfer back to H-1B, they used to have difficulty in transferring back to H-1B because the USCIS used to say that the B-2 was not approved, hence we are not going to approve the H-1B with the I-94. But since March of 2023, USCIS has notified in the website that it is encouraging people who are on H-1Bs, L-1s who loses a job, they can stay in United States on a B-2 application. And while the B-2 application is pending, the USCIS will, if there is a job offer, the company can file a change of status from B-2 to H-1B, and they do said that they are going to approve the H-1B status with the I-94. That means that the person don't have to leave the country. Now, time and time again, we have filed so many B-2 applications, had no problems with it. Time and time again, we have filed, this is from March of 2023, I would say. If the B-2 application is pending, we did file the change of status to H-1B, had never been an issue changing to H-1B. We got every of those things approved, had no issues. Now, people have questions at what time they can file the B-2 application. How long will the B-2 application that people can stay? Well, you have 60 days, assuming your I-94 is still valid for the 60th day. You have 60 days for you to file. Let's say you're working with Intel and now you lost a job. Let's say your H-1B is expiring in March of 2025. Now, let's say you lost a job yesterday, which is August 5th. You have until 2 months, which is almost October 4th of 60 days, October 4th of 2024 to file the B-2 application. Now, this application can be filed online and you can consult any of us. We'll help you file online. We normally tell you to fill the application and then come up with all the questions. And then afterwards, you can file the online applications. Very easy to file this online application. Normally in a consultation, we just let you file the online application. People, and that is, we normally tell people to file on the 58th day, because since you're filing online, there is no hurry for you to file the application 20 days before, 30 days before, and you tend to do very less, if not none, mistakes when you file online applications, especially in the guidance of an immigration lawyer. So you can file it online 2 days before the 60 days, And from that time onwards, you have up to 6 months to apply for the B2 application. So from October, let's say October 4th onwards, you have until April 4th, if I'm not mistaken, until April 3rd of 2025, you can stay in this country, but that is 6 months from October 4th. And in the interim period, if the B2 is pending, if you get a job, you can convert that into H1B. The only caveat here is that you have to wait until the H1B is approved, which in premium processing, it's going to take approximately 2 to 3 weeks for you to get an approval. So, and a lot of companies, lawyers are aware of it. Initially, they were not aware that you can transfer to B2 to H1B. We have mentioned very many times that you can, and they have got their B2 approvals. And while the B2 is pending, the companies have filed a H1B change of status, and no problem, none whatsoever at all, Emily.
Now, how does that B2 compare to the I-140 Compelling Circumstances EAD, where obviously with a B2 you cannot work? This Compelling Circumstances EAD allows you to work. Why would we suggest people file the B2 instead of the Compelling Circumstances EAD?
If you file the Compelling Circumstances EAD is only for those people who have an I-140 approval. If they meet certain conditions, which most of the people might be, because they might have a mortgage, children going to school, and transiting from here to India after staying for a long period of time here. So yeah, you can be eligible for a Compelling Circumstances EAD for those people, and that Compelling Circumstances EAD is only for 1 year. And it's unless the compelling circumstances is extended beyond the control, though, you can't extend it. Yes, you can file the Compelling Circumstances EAD. However, one caveat point here, Emily, is that when people want to convert from Compelling Circumstances EAD, let's say on August 5th, the gentleman has been laid off. We have until October 4th to file the Compelling Circumstances EAD. We can file the Compelling Circumstances EAD. While the EAD is pending, he cannot start working with the company. He has to wait for the EAD to approve, which may take anywhere between 2 months to about 6 months to get the Compelling Circumstances EAD. In the interim period, he and his family, if they file an EAD also, they can stay in the country, but they cannot work. Once the EAD is approved, they can start working. However, one caveat here is that if they later on want to change the status to H1B, they cannot change the status in the United States, because compelling circumstances is not a non-immigrant visa status. It doesn't allow people to change the status from compelling circumstances EAD to H1B. So they have to leave the country and get mostly people's stamping might have already been expired, and they have to go and get the stamping and come back. And the problem here is that the companies are not willing to wait for people to go and get the stamping and come back into the United States. Compelling circumstances is only valid for 1 year. So previously, we may have encouraged people to go to compelling circumstances EAD, but now we're kind of pushing more towards the B2 because it's giving a good transit back to H1B without leaving the country.
Yeah, and that's based on the USCIS website update. Really, there's not been a change in the law, but as layoffs were happening over the last couple of years, they did update their website with the B2 as an option for people who are being laid off, and they specifically state that they will allow people to convert back to H1B even if the B2 is still pending, as long as the change of status back to H1B is filed in premium processing. And they will approve the change of status with the I-94, putting you back in H-1B status without you ever falling out of status, without you ever having to leave the country, which is much better than what the situation was before that update, because people were having to leave the country in order to get back to H-1B, even in the case when they filed a B-2 before, which is why most people weren't filing B-2s in that situation.
You've been quoted in the Bloomberg News, which is the national news here in, it's a national news in India, and all headline news. Bloomberg News published an article on multiple filings by some individuals who owned many companies, though, and they've given an example of one particular guy. I don't want to name that particular guy. His last name happens to be my last name, too. But yeah, and it seems that one particular company owner had 15 or 16 companies, and then he filed multiple applications. We have seen this before. And some of the people did argue before that, hey, one, if the ownership is not common, can a person file multiple applications previously though in 2022, 23? What are the circumstances?
No. I mean,
Did
we
you
were
say
telling,
yes or no, Emily?
no, they were not supposed to, at least. We told people not to do it going back before the electronic lottery. We were telling people not to file multiple H-1Bs because we were seeing these issues. So prior to that, they, if the requirement was 2 companies could submit applications for the same person, and it wouldn't have any impact. But then they realized that companies were working together to submit the same lists of people. So one company submits 50 names, another company submits the exact same 50 names, which suggests that the 2 companies were working together specifically to increase the chances of some of those people getting picked. And so last year they did say that that was not allowed. They consider that to be collusion. And they said that they were going to be referring people to law enforcement who were doing that. And then they changed the lottery to make it that beneficiary-centric system, so people are not benefiting by having these multiple H-1B registrations submitted on their behalf. So the difficulty with USCIS is they're kind of coming up with a solution or a Band-Aid after the problem already occurs. They're never really getting out ahead of it. So they're always looking backwards and making changes based on what went wrong in the prior years. So the changes have been somewhat positive, but the fact that we have another lottery this year, maybe there were still a lot of not genuine registrations again this year.
So a lot of people ask me the question, why the H-1Bs for these people don't get revoked immediately though? Why they don't get revoked at all? They do get revoked. We do see a lot of them. We do get a lot of consultations when these H-1Bs which have been selected in 2021, 22, 23, especially in 22 and 23 though, they get revoked now, especially in 2023 when the electronic lottery came in. It's only $10. People didn't care and filed multiple applications. So the USCIS is not as fast. Our ICE, Immigration Customs Enforcement, is not as fast. As Emily has pointed out, they always go for the Band-Aid and they try to revoke the applications afterwards, not at the time of filing the application, because they probably don't have enough time to review all those applications. And then once they're approved, they go back to those things and go and revoke these H-1B applications. Now, in 2023, though, they did publish the amount of people who filed the duplicate applications. They were a very great number. 90,000 people have filed almost like 400,000 applications. And all those people's, their names, their company names, their date of birth, their passport number, they already have it, though. Those people already have it. And I know this number what I'm speaking about is only in 2023, July they released it, but before they have also released in 2022 lottery how many people filed for the duplicate applications. And of course, they didn't publish their names and company names, but the USCIS has it with them, the names and company names. And we do see time and time again that they do go back and revoke the H-1B applications. One reason why we differ from the other law firms that may have promoted duplicate filing to us is that simply if the job is only one, then you can only file one application. That is the premises of it. Since these are consulting companies, let's say, for example, with an ABC consulting company, you're working with Coca-Cola company, which is the end client. The job is with Coca-Cola company, and of course, ABC consulting company has it. If the ABC is filing a H-1B, we don't have a problem. But ABC is filing it, and there is a D company, E company, F company, G company filing with the same premises that they have a job with Coca-Cola. That is a problem, though. Now, a lot of people ask me a question. Now there is no common ownership between ABC company, D company, E company, and F company. No, that's not the reason. It's entirely fraudulent application because the job did not exist with company C, company D, company E, and company F. And that's the reason why. And we have noticed that when people go to the consulate, They are getting barred forever. They've been called into a small room. They've been asked questions about it. They've been barred. They've been said that since you have misrepresented in collaborating in filing the multiple applications to increase the chances, you have misrepresented to obtain an immigration benefit, which is a lifetime ban. That means the person can never ever come back into the United States. Now, normally USCIS, when they revoke the H-1B applications, they may not do it, especially when the person goes for H-1B stamping or the person is going for H-4, even though the H-4 is not linked with the multiple filing, the person was involved with the multiple filings, the H-4 can still be revoked, can be barred to ever come back into the United States. So anybody who have been involved in multiple filings, and you're right now even not working for that company. Let's say company A filed the multiple filings for you. Now you're working for even Apple company. Let's say Apple company also. You still may get a revocation for the or when you extend the H-1B with the Apple company, you may still get the H-1B denied. So be careful on that thing. You may want to consult an immigration lawyer to make sure what are the rectifying methods if you can do on those things. Anything else, Emily?
Nope, I think we can move on to changing jobs after I-140 approval. So what is the 180-day rule when it comes to I-140 approvals?
The golden rule, Emily. For the I-140, I-140 is given to the employer to an extent, to an employee to extent. As everybody knows that if the I-140 has been approved, you can extend the H-1B beyond 6 years. Your spouse can get the H4 EAD. And you're also you can be able to port the date to a different employer at a later date. However, if the I-140 has been withdrawn within 180 days, you cannot extend the H-1B beyond 6 years if the I-140 has been revoked within 180 days after it's been approved. Okay, and you cannot get the H4 EAD if it's been revoked within 180 days after it's been approved. Many questions come in. Hey, I left the company. Well, if it's not whether you left the company or whether you're with the company, it's whether the company withdrew the application within 180 days. If the company withdrew the application within 180 days, then definitely you cannot extend the H-1B beyond. Now, a lot of people are already aware of this 180-day rule, and then they ask question, now when they join company B, Emily, does the company B, let's say the I-140 has been filed with company A, got the I-140 approval, this gentleman stayed with the company for 180 days, then he moved to company B. Company A has an I-140 approval. Company B is the new company, though. Of course, this gentleman's priority date is 2020 from India, and it's at least not expected to be current pretty soon. Does the company B needs to file a PERM and I-140 to extend the H-1B, not initial filing? At the initial filing, company B got the H-1B approval based on the company A's I-140 approval. But to extend the H-1B for company B, does company B need to file a permanent I-140?
No. Company B can continue to use company A's I-140 approval to keep extending that H-1B beyond the 6-year limit in 3-year increments as long as the priority date is not current. It's not necessary for company B to start the PERM process or have the I-140 approval in order for you to keep extending. You can keep using company A's forever until your priority date becomes current for purposes of extending your H-1B and your spouse's H4 EAD.
What about the person wants to move from company B, which doesn't have an I-140 approval, but it's only I-140 approval with company A? Can he move to company C using company A's I-140 approval?
Yes, you can transfer to company C, company D, company E, keep getting extensions with company E, and then transfer to company F without company B, C, D, E, or F filing a PERM or I-140. You can keep using that company A I-140 the entire time.
Well, the priority date is not current, and now I want to move to India, and I want to stay there for 6 years, and priority date will still not be current for me. can I use this company A's I-140 approval to come on company C? And I stayed in India for 7 years now. Can I
Yes,
come back?
absolutely. Yep. Yeah, so you can use company A's approved I-140 to have company C file an H-1B petition that is not subject to the cap because you've already been counted. You do not have to go through the lottery. They will file it for consular processing because you're outside of the country. As soon as it gets approved, you get the new visa stamp and you come back to the US, continue your H-1B status, keep extending your H-1B with that company, still using company A's approved I-140.
I'll move to the next question. The 221G, it's an administrative processing. I heard you say somewhere before that you have to mention your visa has been refused, denied, rejected. Why? It's just an administrative thing. Why do we have to mention that in the DS-160 when we file the application, when we go for the green card application, the 485 application, why do we have to mention our visa has been rejected when it's only administrative thing?
Yeah. Department of State takes the stance that administrative processing really means we've denied your visa for now, but we're still looking into it and we may approve it later. So even though the process is not over and there's still a chance for approval, they consider it to be initially denied or refused. And so therefore you do have to list that on any future DS-160s and also on your 485 application, because both of those ask, have you ever been refused a visa before? Now, just having a visa refused due to administrative processing is not a ground they can use to deny your new visa. They can't use that as a reason to deny your 485. So I don't know why they ask those questions, other than to catch people if they answer no by mistake. I don't know. But yes, you do need to disclose that, answer yes to the question, have you ever been refused a visa, if you've had a 221G or administrative processing in the past.
Can we go to questions, Emily?
Yes.
Shilpa is asking this question. She got the green card and the employer is telling that she has to work with the company for 6 months. Otherwise, the company is going to revoke the green card. Is that a possibility that company can revoke the green card? No, no, no. They cannot revoke your green card. They cannot. Green card can be revoked only for fraudulent purposes, though. So, for example, if you have provided the education certificate from Osmania University, but you never studied in Osmania University, definitely that's a reason for revocation. But no, 99.999% of the time, the companies cannot revoke, and they don't even have our authority to revoke at all. It's not like I-140, it's not like a H-1B, which they can withdraw the application. Green card is yours, Shilpa. It is given to you personally. They do not have an authority, they cannot revoke it, they cannot withdraw it, it's yours. You can leave the company within the 6 months period, absolutely no trouble. This question is asked many times. Oh, that lawyer is telling me that I have to stay for 6 months. Not true. At the time of citizenship, you will have trouble. Not true. In fact, the AC-21 rule says that you never have to even work for the company. Now, I don't want to go into that detail at this point of time, but to answer your question, Shilpa, you can leave the company, absolutely no problem.
All right, Deval from X is saying, any updates on H-1B and the impact of the layoffs on the second lottery? It may be a little early to tell. We're still going through our selections to make sure we caught all of them, all the new selections. I believe USCIS had indicated that they selected about 14,000 more in the second round. All of our attorneys were having trouble accessing our My USCIS accounts yesterday because the two-factor authentication was not sending the access code. So we're trying to get logged in again and make sure that we have all the selections. And then we're still reaching out to employers to let them know and confirm whether they're going to be filing. As of now, for mine that were selected, 100% of those employers are moving forward with the filing. So I'm not seeing an issue, but I would suspect, yes, there are going to be some people who got selected this round and no longer have that job, which means the company won't be filing. Is it going to be enough to trigger a third lottery? I think it's going to depend on how much worse the job market gets over the next 2-3 months while we have the filing window open.
VVM has this question. He is on GC. If he gets laid off, can he do side jobs until he get the IT job? Will that impact applying for citizenship application? Will that impact? You have no limitations, sir. You can work as a flipping the burger in McDonald's. You can be the Microsoft CEO. Oops, that reminds me that Satya Nadella and some of the people have become the CEOs of the company too, while they're on the green card. Yes, absolutely no problem. You don't have any restriction. You are a green card holder. You can do anything you want, or you can just sit at home and do nothing. And still you will have no problem in getting the green card.
Archer says, I was laid off. My H-1B was picked this year and already approved, but my company is not providing me with the approval notice. Can I still transfer my H-1B to a different company? And can I do it using Freedom of Information Act or FOIA? Maybe. So part of it depends on if the company has already withdrawn the approved H-1B. Or if they're planning to do that before October 1st, because if they do, USCIS in a transfer situation can say you're not actually considered counted in the cap yet because your H-1B was withdrawn before it took effect on October 1st. So you'll want to try to find out if that H-1B was withdrawn. You may be able to figure that out just by monitoring the online case status, using the receipt number, because USCIS usually does say we've received your correspondence, and then they will say we've sent a notice of revocation or something like that. You can also try a Freedom of Information Act request to see if any of the documentation comes as part of that. In terms of filing a transfer, assuming they have not withdrawn it, you should be able to print out the online case status showing that receipt number and showing that it's approved, and let USCIS look up on their own that approval is for you and that it is valid to allow you to change employers. There still may be some risk in filing that transfer before October 1st. Because technically you're not in H-1B status yet. Sometimes in the past, USCIS come back and said you haven't been counted in the cap yet, therefore we can't accept this transfer yet. I have not seen that in the most recent years, but that is something they did do in the past.
Vivek Batul has this question. On OPT, can I work in a school as a teacher? Absolutely, you can. No problem with it. A question that comes here from Sri Lakshmi, she's a Canadian citizen. She's a physical therapist. Can you open a home health care setup in USA with 75K? Am I eligible for e-visa though? You're speaking, I think, so it's E2 instead of E1. You can, but I would rather want the investment to go up from more than 75K though. Because if you're just self-employing though, that may not be enough to get the E2 visa. It should be a establishment. Let's say, for example, you have a store, which is like, people, when you go to the mall, people are standing up there right in the center of the mall and they're selling something, maybe jewelry or maybe some makeup things, those kind of things. They may not qualify for E2 visa, but it's a gas station kind of thing, or maybe a full-fledged physical therapy unit, which has like a couple of employees, maybe should be easily eligible for E2 visa though. For those people who are getting confused, what is this E2 visa? This is not, Indians are not eligible for E2 visa. Definitely Canadians are eligible, even though they were Indian citizens born in India, but they hold a Canadian passports, they are eligible for E2 visa.
Nature Lover says, how long can an H4 stay in the US if the H1 goes out of the US for a 1-year assignment? I would say 0 days. You either need to go with your spouse, because the whole purpose of the H4 is for you to stay in the US with your spouse who's on H1B. If your spouse is not on H1B anymore, there's no purpose for you to be in the US. You could consider filing a change of status to B-2 to stay for an additional 6 months, but I would not do that on H4.
Bautik Patel has this question. If the company A withdraws the I-140 after 180 days of approval, it should not affect the H-1B renewal. Is that right? The answer is right. Once the I-140 is approved, it's 180 days. The company can withdraw it, but it will not negatively affect H-1B renewal for you.
Arvind says, if my employer revokes my H-1B due to disagreements between us, can I still transfer my H-1B to another company? Yes, as long as your I-94 has not expired. You basically, even though the employers sent notification to USCIS notifying them that they terminated your employment, you still have the 60-day grace period. So as long as your I-94 is valid for more than 60 days, you have the 60-day grace period, regardless of the reason why your employment is ending with that company, regardless of the fact that they've sent a withdrawal request to USCIS, and you can transfer to another company.
Muthukumar has filed the H4 and he did not still get a receipt notice. He's asking the question, can he file a change of status without a receipt notice? No, that's going to create a problem. That's going to create an RFE. I would wait for the receipt notice before you file the change of status. So what you can do is that check to see if the check that was being sent for the H4 has been cashed. If that has been cashed, though, you can look into to see if there is a file number. Based on that, you can print the receipt notice, not the exactly receipt notice, but the online receipt notice that it is pending, and then file the change of status application.
Clevy says, can the H4 EAD go away under Trump? Is there a risk? Yes, it can. He started that process before. It has to go through regulation. And he had a proposed regulation on the agenda to basically eliminate the H4 EAD. It never actually got proposed in the Federal Register. I think part of that is probably all the different lawsuits that were going on about the H4 EAD, trying to eliminate it through litigation. Those have officially been unsuccessful. Just as of last week, the H4 EAD is allowed to continue. They did say it was a proper use of executive authority in issuing that, which means that it could be a proper use of executive authority should a president decide to get rid of it, as long as they go through the regulatory process.
What about the Dreamers, though? Trump tried to get rid of it too, but the courts blocked it, didn't they?
Yes and no, because he did succeed in eliminating it for new people. Okay. So someone who's only now becoming eligible can't file. Right now, only people who already had it before are able to continue extending. So he was not successful in blocking people from continuing to renew, but he was successful in blocking people who new people from filing.
So it's a partial success to Trump administration, partial success to us in there. So in other words, so we have a chance of litigating when this guy tries to bar it, though.
Yeah, for sure.
There are questions with regards to where the company is not filing the H4 plus EAD. What are the best options in that case when the company is not filing the H4 plus EAD along with the H1B? We still recommend to get the H1B. This question comes from Abhisri from YouTube. We still recommend that you still get the H1B approved in premium processing. And with the approval notice, you file for H4 plus EAD. And if you come very near to the EAD, assuming that this is an EAD extension, though, there are ways, if the H4 and EAD is not approved within that time, before the H4 is expired, you can go to Mexico and come back, and they will extend the H1B beyond to the time the H1B is approved. There is a video we made it where you can use the 540-day rule, but you can consult an immigration lawyer and they will guide you that while the H4 is pending, your H1B is approved, She travels to Mexico. She uses the I-90 H-1B of you. When she comes back into United States, she will be given the I-94 until your H-1B is approved. You may ask a question. Her passport visa is not valid. It's expired. How she can go outside the country? There is an exception for automatic revalidation if the present I-94 for her, this which is valid with the H4, she can still travel outside the country and come back in, and she can still request based on your H-1B approval. 98% of the time, this is successful when you fly to Mexico and come back.
R100 says, have you heard any rumors on the upcoming DHS proposed rule change called Modernizing Regulations Governing Non-Immigrant Workers that is slated to be announced in January 2025? So this is on the current regulatory agenda. It was on a previous agenda as well. I don't have any rumors on exactly what's included, but we do know that they're planning to update EAD rules for dependent spouses of certain non-immigrants, increase flexibility for certain non-immigrants, including those who resign or are terminated from employment, and modernize policies and procedures for EADs. I would say those are all positive changes that we can expect in this Biden administration. But what those changes will be, how positive they will be, it's hard to say. This could just be them putting in the regulations some of the policy changes that they've already made, which means it doesn't really amount to much actual change since we're already taking advantage of those changes. We don't know for sure, unfortunately.
Anupam Sharma has this question. After traveling back in EOS, what he means is that advance parole, can he move back to the H-1B status? My main, or does he need the Margarita switch? Main question right now is that when you entered into United States, did you already have the H-1B? I'm not speaking of the H-1B stamping in the passport, but the H-1B I-797 with the I-94. If that is the case, though, once you come into United States, practically you are an H-1B. You can extend the H-1B, you can transfer the H-1B, you can amend the H-1B. So you are on H-1B. What looks like a duck, walks like a duck, talks like a duck is a duck. Well, I have some disagreement with some people, including the person sitting next to me here, but still, I say it's a duck. Emily says that, yeah, you can extend it, but at current you may not be, is her argument. But I believe that you are still on H-1B if the I-797, I-94 is valid, even though your online I-94 says it is advanced parole, and that is expiring within 1 year. But if you have I-797 H-1B, you can extend it, you can amend it, you can change it to a different company.
Raj says H-1B premium processing status changed from RFE issued to cancellation within 2 hours, and then the next day RFE is again issued. Is this normal? Anything these days with USCIS is normal. They're doing all kinds of crazy things that I've not really seen before. I've had N400 interviews issued, canceled, issued, canceled. Same thing with oath ceremonies, issued, canceled, RFEs. They're doing all kinds of weird things. So I would say, no, it's not normal, but it's happening. So I would not be overly concerned about it.
Emily, I had a recent consultation with a person. They filed the H4 EAD for the child, and the USCIS has approved it, and they even extended it. When the child was turning 21, when they applied for the F1, they said, you worked illegally in the United States. Yes, please, the children are not eligible for H4 EAD. Don't listen to this and file it H4 EAD. You will be in trouble. H4 EAD is only for a spouse, not the children.
Actually says, having already used 3 years of OPT after my master's, if I apply for a new F1 visa in my home country, will the consular officer interviewer check my employment history and ask any questions on it? Yes, because when you complete the DS-160, you do have to list your employment history. So you do need to mention all companies that you worked for, on OPT. So for example, if you got an offer letter from Wireclass or AZ Tech or Integra, and you list that you worked for them on your DS-160, I can guarantee you the interviewer is going to be asking you a lot of questions about that. So yes, they can still check into that. Now, most of when you're going for a visa interview is looking forward. Going forward, do you qualify for the type of visa that you're applying for? And are you coming to the US for the proper purpose of the visa? But if there are red flags, they can certainly look backward to determine whether you've misrepresented something somewhere, whether you've committed fraud, whether you've worked without authorization. All of those things can come up during an interview.
Daya Sagargadde has this interesting question. His H-1B got picked in the second lottery. He has an approved EB-1C I-140. Should he change from L-1 to H-1B? Any impact on EB-1C application for green card if I change to H-1B? Assuming that you didn't file the 485 because your priority date is not current, definitely you should change to H-1B. The reason is that we don't know how long it's going to take for your priority date to become current. And then L1A expires in 7 years, you cannot extend it. So definitely, no, there should not be any impact on changing from L1A to H1B for the green card application.
Palumi says, how long is it taking to renew a standalone advanced parole? And what happens if I travel while it's pending? Can I expedite it? It's been more than 6 months since I've filed. They're taking anywhere from 3 months to 18 months. It is all over the place. There's no rhyme or reason to it. If you travel while it's pending and your previous advanced parole is still valid when you're returning to the US, that's fine. But if your previous advanced parole has expired, you don't have a way to come back on the pending advanced parole. So you need to be careful with that. Can you expedite it? We're not seeing much success with that. Can you litigate it? Yes, absolutely. You can file delay litigation for these APs. We've been doing that quite a bit. So you can reach out to Stephen Brown at RN Law Group to discuss that litigation option for your delayed AP.
Prasad has this question from Facebook that if his H-1B is expiring in August 2025 and he's changing the address to his home, can the employer file an amendment plus extension? The general rule for the extension is you can only file 6 months in advance, not before. But in case of amendment, though, you can file amendment plus extension. So in Prasad, in your case, even though your H-1B is expiring in August of 2025, that's almost 1 year from now, you can file the amendment plus extension. We always recommend people to file amendment plus extension if it is especially 1 or 2 years left in the H-1B. That's the best way to do it.
Aryan says, can you share some information for consular processing for Canadian citizens? Previous I-140 approved in 2013, Indian born. So consular processing, if you did not specify on your I-140 back in 2013 that you were planning to consular process and now you're planning to do it, your company needs to file an I-824 application to notify the consulate of your I-140 approval. Once that gets processed, your I-140 file will then be transferred to the National Visa Center. They will assign it a case number for the consulate where you're going to apply in Canada. They will send you an email with that case number as well as an invoice ID number. You will log into the CEAC system, CEAC, where it will ask you to pay some fees, the IV filing fee, the immigrant visa application fee. You would not have to pay the AOS fee. Don't get that confused with adjustment of status. This is affidavit of support. You don't have to pay that because you're an employment-based, I'm assuming employment-based applicant, so you skip that. Then you will fill out the DS-260 visa application form instead of the DS-160. Very similar form though. You will then have to upload your, actually right now, NVC doesn't allow employment-based applicants to upload documents. So you have to mail in your civil documents to the National Visa Center. That's typically going to be your certified copy of your birth certificate, your marriage certificate if you're married, biographic data page of your passport, and police clearance certificates from all the places you've lived outside the U.S. For over 6 months. NVC is going to review all of that. If all is good, they will tell you you are documentarily qualified, and then they will schedule you for an interview at the consulate. They will at some point transfer your file to the consulate, and then you're just at the whim of the consulate to actually have interview dates available for you. You will then get a medical exam done, go to your interview, and then if all is successful, get approved and get an immigrant visa stamp in your passport, along with an envelope that you will carry with you at the port of entry. And your green card will then be mailed to you after you arrive in the U.S.
Emily, there's a good question from Vivek, and I want you to prepare for this one mentally, that his teenage kid wants to do some part-time work to gain some experience, not, voluntary work. Can they do it on H4 though? What are the restrictions that they have on the H4?
Unfortunately, no. H4 kids are not authorized to work, even if you're doing it without pay. It's still not authorized, and it's still considered employment if it's a job that a company would normally pay someone for. So if, for example, we have interns here in our office, we normally pay our interns, and then some H4 high schooler says, I want to intern in your office over the summer just to see what lawyers do. They're not allowed to do that because it's considered to be unauthorized employment, unfortunately.
Emily, in the hospitals, though, they do have volunteer opportunities only for children, though. That's not, every year, every month, they have certain duties that they provide. Can they do that job?
Charitable work, yes. Volunteer work, meaning like volunteer for a charity, yes, that is fine. But volunteering to gain experience, to gain exposure for your future career is not allowed.
Okay. Sandeep Malladi from X and also from YouTube, I'm assuming he's the same person, has this question. Can he get a real estate license on H1B? You should not, though. The reason is that I'm assuming that your H1B job position is not in the real estate field. And if the USCIS finds that you have a real estate license, then they may presume that you started working as a real estate agent. Now, can people just get the license and not work? These professions have to be maintained certain minimum education, certain requirement to work. So definitely it catches the attention of everybody. Why did you get that license when you're not working? Did you work for anybody? Did you volunteer for anybody on the real estate? So definitely I would recommend you not to get the license of real estate.
My Little Nest has a question about CESPA, Child Status Protection Act. My priority date is January 2013. Had a change of job and I'm stuck in the PERM process. My son is aging out in 7 months. If I apply my I-140 after he ages out, will the CESPA rule apply? So the CESPA rules are based on whichever I-140 you're going to be using to file the 485. And so if your son has already aged out before you even get to file this I-140, and this I-140 is the one that you're planning to use for your adjustment of status, unfortunately, he won't qualify. If you were able to somehow go back to your old employer and file the I-485 when the priority date becomes current for January 2013, then you can take that old I-140 amount of time it was pending and subtract it from his age and see if that gets him under 21 when your date becomes current.
If applying, this question comes from Gagan Mishra, that if he applies for renewal of AP and EAD together, does the approval come together or does it come separate? Sometimes it comes together, sometimes it comes separate. There is no clue how, when, why. Sometimes they come together, sometimes they get separate. When they come together, though, the advance parole normally is approved in a short period of time. When it gets segregated and it gets separated, though, it may take a long time to get an advance parole.
Kala says, is it possible to consider my work as a manager in India prior to 2010 from company A for filing EB1 now with company B? Not with company B. So EB1C works for positions that are manager or executive in the US, but you had to have worked for a parent, subsidiary, or affiliate of the same company in India for at least 1 year. So since I'm assuming company A and company B have no relation to each other, you can't use that year of experience abroad to file an EB1C with company B.
I got an offer from another company. This question comes from Dilip. And they filed H1B, got the H1B stamped in March 2024. Haven't moved to USA. My company in India, being an MNC, promised to file L1A. Suggest which one is better. Dilip, the question is that promised and doing L1A is better. If they're doing L1A right now, I would prefer to come on L1 because you already stamped in the passport. You may be able to use that at a later date to move back to any other company on H1B. But the reason I'm a bit hesitant in relying on that promise is that, well, they do promise a lot of people on L1A, but will they do the L1A? So if they do the L1A, probably L1A is better because the green card prospects to get the L1A to green card is faster than that of a different company which you did not work in India. So if the L1A has been given to me right now and they applied, I'm going to go for L1A. If not, then definitely I will think of coming on H1B with a different company.
San says, I'm currently working for employer A, recently got my I-140 approved with my past employer B while I'm working at employer A. How does the I-140 180-day rule work here? So it doesn't matter what company you're working for. What matters is company B, your old employer that just got the approved I-140, going to withdraw the approved I-140? If they're not going to withdraw it, you don't have to worry about it. If they are going to withdraw it, you want to have them wait 180 days from the day of approval before they withdraw. Because if they withdraw before 180 days, then you cannot use that I-140 for purposes of extending your H-1B with any company beyond the 6-year limit, and you can't use it for spouses H4 EAD. You do still get to keep your priority date, though, regardless of how long that I-140 has been approved.
Raj has this question from YouTube that his H-1B extension got denied in RFE. Can he travel outside? His passport stamping is still valid for the next 10 months. So my question is that you at one point of time, you said the transfer of the H-1B got denied, transfer plus extension got denied. And in this point, you said your extension got denied. So I'm a bit confused. Which one is it, though? The question is that normally we file only extension if it's expiring within 6 months. You're telling that the H-1B is valid for 10 months. I'm a bit confused here with your question, though. But I will tell you one thing, though. If you're working for company A and company A filed the extension gets denied, and you're traveling on company A's H-1B stamping, even though it's already been approved, I will not travel. If you're working for company A, you transfer to company B applied for a transfer, and that company B H-1B transfer gets denied, and you're still working with company A, I do not see any problem in you traveling because company A never got any of the H-1B denied. Company A did not get anything denied. The stamping is good. You can travel. I don't see any problem with it.
Hema says, let me know the wage level qualifications. Example, what's the level 1 wage, minimum education experience required, level 2, 3, and 4. So these wage levels are used for LCAs and PERM labor certifications if you're not using a private wage survey and instead are using the OFLC data center that is put out by the Labor Department. When they provide a prevailing wage, it's for a specific work location, usually the county or major city. It's for a specific occupation, so you have to know the SOC code, And then it's for a specific wage level, 1, 2, 3, or 4, 1 being the lowest, 4 being the highest. There's no set number of years of experience or education level that applies to every single wage level, because it depends partly on what's normal for the particular SOC code. So if a particular SOC code normally requires an associate and your job requires a bachelor's, because you're requiring more than what's normal, a higher wage level is going to apply. But it's always based first on what's normal to the occupation. Then we look at, are there any supervisory duties associated with the position? And then what's the complexity of the position? In general, wage level 1 is meant for entry level positions, 0 years of experience. Wage level 4 is for very complex positions involving supervision, team lead, that sort of thing. So 2 and 3 are anywhere in between. They specifically say senior positions tend to be level 3. Anything that's not an entry-level position doesn't rise to the level of senior is likely going to be level 2. So I would say most jobs are probably level 2. There's not a ton of jobs that you sponsor visas for where you require a degree and 0 years of experience typically. So that's kind of an overview. There is a specific prevailing wage guidance document from DOL. I can't find it currently on the new FLAG website. I was always able to find it on the old prevailing wage website, so I'll have to figure out where they moved it to.
Srinivas Mati has this question from YouTube that his I-140 has been approved under EB1 in January of 2024. I-485 has not been filed. Can we switch to the new employer? Can his new employer use the EB1 to file the 485 application? You did not tell me whether it's a EB1A, EB1B, or EB1C. If it is EB1B, which is outstanding researcher, the company, when you move to company B, the company B cannot file the adjustment of status. They have to file the I-140 again. If it is EB1C, the same rule, companies B cannot file the adjustment of status. Most probably 99.9% of the time, company B will not be eligible for the I-1 filing an I-140 under EB1C at all. EB1A though practically may, when you move, assuming that EB1A is filed by the company, because EB1A can be filed by the company or an individual. Yes, under certain limited circumstances, if EB1A has been filed by the company, you can move to company B. Company B can use the old I-140 because the EB1A is given on the merits of you, not of the company. So it can be under limited circumstances used. But EB1B and EB1C, no.
Galactico says the H-1B maxes out in September 2024, just around the corner. Got my PERM approved in June 2024. What if I file the I-140 in regular processing, not in premium? Can I stay in the US beyond September 2024 and file for a 7th year H-1B extension? Most likely, yes, because I'm assuming that your PERM was probably filed in June 2023 or earlier, since they're taking a year to process. So in that situation, to get a 7th year extension, you have to show that your labor certification was filed at least 365 days before you hit your 6-year limit. So since your 6-year limit is September 2024, as long as your PERM was filed before September 2023, you can still get a 7th year extension, just 1 year, based on your pending I-140 in that situation.
NW has this question. I have an H-1B approved back in 2006 and it's unused. Can I reuse that now by transferring it to the new employer? When you say H-1B is approved, did you get the H-1B stamped in the passport? If that is the case, you may be able to use it. Even though it is 2006, you can still use it. But if it's never stamped in the passport and you were never here, you were never in USA and was on H-1B on the I-94, then you may not be able to use it. You have to go through the lottery system. To be counted toward H-1B, either the H-1B has been stamped in the passport or the H1B, you have been on H1B and I-94. If none of those things occurred, you have to go through the lottery system. Srinivas Mati is saying that it's EB1C that his I-140 is approved. No, you can't move to the different company and use that to file the 485 application. No, under all circumstances, Srinivas, do not move out of the company. It's very dangerous. You will lose a lot of those things. Don't leave the company.
All right, well, I think we are out of time for today. Thanks everyone for joining us. As always, we will be back next Tuesday live at 5 o'clock Central Time to answer your questions and give you the latest updates on everything employment-based immigration.
Thank you very much for tuning in.